Welcome to you, my hardy band of viewers, with a taste for something perhaps a little more esoteric than some of the other stuff out there. I have to say, I didn't expect it to be so much fun. I mean, the idea was to do some videos on the law, and I've done some of those. Have a look. It then became focused on jurisprudence. My last few were on natural law. And then it really got interesting because I started to see this is a great place to examine where the world, this modernist or postmodernist world, went wrong. Law is really actually a really good place to start. So as a channel update, I am working on my next videos on legal positivism. They're coming. It sounds a bit boring, but as I started my research, it really got me thinking from what I was seeing when legal positivism came on the scene. And that's really what we think of law today. It's what the assembly does, with the laws it passes, what the courts decide. That's the law. Then there's regulations and other such things. People think that's what the law is. And that really got rolling in the 19th century. But I think this was really a legal coup d'etat, another one of the blessings of the Enlightenment. And forgive my name, but I'm more of a despot than an enlightened despot. Because literally for thousands of years, law was a complex mix of, yes, dictates from the sovereign, but also custom, tradition, religion, morality. Then it just ended rather abruptly. And I think we need to think more about what happened and why. Philosophers like Locke and Hume and Bentham and legal theorists like John Austin had a goal of bringing the law into the modern world. Make it more empirical, more utilitarian, more rational. What happened, I think, was that law lost many of its legitimate, interesting word, many of its real sources. You could say it lost its soul, but certainly it lost the ability to supplement a modest amount of law, legislation, dictates of the state with other sources like morality and ethics. It became simply what the state says the law is. This, I think, was the beginning, not just a prelude. It was the beginning to the actual law as power in all the other systems, I think. And we'll see if I continue to view it that way. But I really do see now the distinction between natural law and then everything after. Now, with no moral or ethical system to plug the gaps, to answer legal disputes or solve legal problems, the gaps were filled with laws and more laws and more laws and more regulations and lengthier statutes. And take a look at any statute coming out of Parliament. It's incredible nonsense. And laws now, as I've said, laws and regulations clog the arteries of the modern state such that you can have a Hillary camp accusing a Trump camp and vice versa breaking the law. Both are probably right because there's so many laws out there, so many ways of interpreting them, that we could all basically be breaking the law all the time. Now, a few notes on what positive law is before I go much further. Just sort of share a little bit of what I'm finding here. This is from Legal Positivism, edited by Torben Spack and Patricia Mindus. This is Cambridge. What is law? Although the subject matter of jurisprudence, sometimes called legal theory, is not understood in precisely the same way everywhere, everyone agrees that the question of the nature of law falls within the purview of jurisprudence. The central question is, what is law? or what is the nature of law. And it is usually here that one encounters legal positivism and its main challenger, natural law theory, for the first time. The central question in a debate between legal positivists and natural law thinkers, the perennial finalists in the World Cup of legal theory, is often said to concern the relation between law and true morality, whereas natural law thinkers maintain that law is necessarily moral. That there is a necessary connection between law and morality, legal positivists hold instead that the relation between law and morality is contingent, that law is sometimes moral, sometimes immoral, and argue that the question of whether we have an obligation to obey the law can be answered only after we have considered the content and the administration of the law in the relevant jurisdiction. So positive law is focused on sources. There's 3 or 4 basic things that positive law theorists generally agree on. Most of them accept 3 basic tenets, namely the social thesis, the separation thesis, and the thesis of social efficacy. Crudely put, I'm reading from the Cambridge source, the social thesis has it that what is law and what is not is a matter of social fact. The separation thesis says that there is no necessary connection between law and morality. And the thesis of social efficacy says that the validity or existence of law presupposes that the law is socially efficacious, which sounds like repeating itself. Now, although there are many, many different legal positivists out there, I was struck by one thing because I immediately began to think, well, when is legal positivism coming on the scene? End of the 18th century, 19th century. What's occurring at that time? Well, that's obviously the rise of British power, the British Empire. And interestingly enough, that's when you get English theorists talking about parliamentary sovereignty. Not the first time, but now it becomes part of this legal positivist way of thinking. So that suggests to me that legal positivism is a power theory. And indeed, someone I'm going to have to read more of is a guy named George Jelinek. Let me read a little bit here. This is page 21 from Cambridge. Starting out from the presupposition that legal positivism is premised on the assumption of a strict separation among the world of law, the world of morality, and the social world, Jens Kirsten explains in chapter 11 that George Jelinek's phenomenological theory of reflective legal positivism aims to answer the question of how the world of law is connected to and can respond to changes in the social world. The general idea of Jelinek's legal positivism, he explains, is that a state has 2 sides, a legal side and a social side, and 3 elements, people, territory, and political power, and that these elements have to be structured and defined with the help of the concept of legal auto-limitation of political power. That is, the concept of the state's capacity to limit its own power by incurring legally binding obligations. On this analysis, Kirsten points out the central element in Jelinek's legal positivism is that of political power, which structures and defines the territory and the people, the citizens, and also structures and defines the state by binding it to legal rules, especially constitutional rules. So there you have the idea that rooted in legal positivism is that it's a power theory. A little bit about John Austin. Now, he's considered one of the fathers of legal positivism. Austin was called to the bar in 1818. The following year, he married Sarah Taylor, a remarkable person in her own right. She not only became her husband's main prop, comforter, and literary agent of sorts, but developed a career of her own as a reviewer and translator. Since John Austen's income for most of their married life was small, Sarah's earnings were important for their support. Their daughter Lucy was born in 1821. The Austens moved to London shortly after their marriage and became neighbors of Jeremy Bentham and James Mill. Bentham was the intellectual leader of the Utilitarians, and no one did more than Mill to spread the gospel. Austen's friendship with them thus placed him at the heart of a vital reform movement. His relationship to it helps to explain his large intellectual debt to Bentham. To be sure, Hobbes, Locke, and others also cast a shadow over the province of Jurisprudence Determined, which was Austen's seminal work. Moreover, Austen was no slavish follower to Bentham and criticized many of his ideas. Then, too, political differences between the two men developed and multiplied in the course of time. Nevertheless, Bentham probably had a heavier impact upon Austen's ethical and legal philosophy than any other person. So you have the roots of utilitarianism and legal positivism. What's interesting is initially the idea that we've heard about in natural law theory that there's divine law among other forms of law, human law. That was not excluded by the legal positivists. In fact, Austen accepted that there was divine law, but interestingly enough, he interpreted divine law as what is useful. I'll just read a bit from this is an introduction to Austen's The Province of Jurisprudence Determined. Austen conceived of the divine law as the express or tacit commands of God. While some of his general orders may be discovered by revelation, others are not expressly revealed. How these commands may be discovered is the major issue that Austen addresses in his second lecture. The only indices to them that he discusses are the moral sense of the principle of general utility, which he supported. God's tacit commands may be inferred from calculations and comparisons of the tendencies of alternative classes of types of human actions, their probable effects on the greatest happiness. These tendencies would then serve as the basis of rules from which decisions to act would be deduced. So you see here clear roots in utilitarianism. What I'll do is I'll try to list these sources when I get this thing cleaned up and published. So what thesis am I going to be working on? Let me show you something. Yeah, I put this on Twitter and it sort of sums it up. Will it stand up? But here's what I was thinking. Before legal positivism, which emerged with utilitarianism and empiricism, and the works of the likes of Locke, Hume, and Bentham, and John Austen, in the 18th and the early 19th century, the competent lawyer had to be schooled in ethics, custom, religion, tradition, the writings of the jurists, and the few sticks of laws as they were, to advise on what the law was. Now, it is reversed. Law is merely posited, and the lawyer looks only at the forest of statutes and treaties and tangle of regulations and the case law produced by his fellows. The modern lawyer has no answer to the absurd, the illogical, the unethical, the unscientific, the immoral, and even the evil. He or she is but a quibbler on the interpretation of words, an apologist for the most tyrannical of regimes, with no answer to the above, except to tell us times change. And yet you still hear utilitarianism viewed as a good thing. And actually, I heard something from Neil Oliver on this, I think today or yesterday. Let me just play it. I hope this works. Yeah, this was his theme. Whatever happened to government by the people, of the people, and for the people? So it's the traditional American approach to freedom rooted in the pursuit of happiness. And this is what Oliver had to say about that.
I very much doubt that Joe Biden knows that the concept of the pursuit of happiness likely travelled to the US from my homeland of Scotland. Francis Hutcheson, professor of moral philosophy at Glasgow University during the Scottish Enlightenment, taught his students that, quote, that action is best which accomplishes the greatest happiness for the greatest numbers, and that worst which in like manner occasions misery. Misery, the misery of the mass of the population, has, in my opinion, been not just the inevitable consequence of the policies we've been made to endure these past 3 years, but the intention. Francis Hutcheson believed individual happiness was a benefit experienced by a person working first to increase the happiness of those around him or her. One of his students was John Witherspoon, who crossed the Atlantic to become president of Princeton University. Witherspoon was a signatory of the Declaration of Independence, and it's reasonable to think the presence of that line about the pursuit of happiness was his gift, and thanks ultimately to Hutcheson. But here, rather than happiness, government flunkies sowed the seeds of dread. The behavioural scientists of the so-called nudge units, the underhand activities of the secret squirrels of the laughably self-named 77th Brigade that spied upon dissent from the official line, all a deliberate and coordinated effort to spread anxiety and fear among the tax-paying, law-abiding people of the land. I say government exists now not to defend the right of the people to pursue happiness, but to deny those rights and so enable the enrichment and advantage of a narrow clique of the wealthiest obsessed with power. The intention at the same time is to make as many of us as possible unhappy and condemned to lesser lives. I say that that clique comprises those most fearful, those afraid of their fellow humankind.
So we still hear today that the pursuit of happiness was a great utilitarian good thing. And sure, as Neil says, the greater good for the greater number is certainly better than the globalist pursuit of the most misery for the greatest number to save the earth, fight climate change, or fight hate. But really, the problem is utilitarianism didn't prevent that. In fact, it may well be the root cause of it by simply redefining the good, the utilitarian good. And it didn't take much for them to redefine the greatest good for the greatest number to be the greatest good for the planet, the greatest good to fight hate, the greatest good to fight climate change. So, no, I don't think a return to pure utilitarianism and the declaration of the ideals in the Declaration of Independence are going to solve the problem. So that said, and I hope I haven't been too scatterbrained, but I just wanted to get this down. I do want to conclude with an essay on natural law by George Grant. It's a good summary of what I was trying to get at in my videos and my essays. George Grant's an amazing guy and happens to be Canadian. He's been called one of the most important Canadian public philosophers. And one of his critiques of modernity, one of his quotes is, ours is a world of mass production and its techniques, of standardized consumption and standardized education, of wholesale entertainment and wholesale medicine, more than simply an expression of relationship of man to nature. It also exemplifies a particular relationship of man to man, namely some men's dominance over other men. And in terms of, I'm reading from an essay, by, I might as well give him credit. I guess he doesn't want credit. The title of the essay is, "This Essay is Not My Own, a summary essay regarding George Grant's Metaphysics and Modernity." You can find it around. I just want to talk about a little bit on, Grant and epistemology. Grant had much to say about the modern way of knowing. What is important to communicate within the context of this paper is that Grant recognized the modern foundation of knowing to be quite different than that of the ancients. The summary provided here regarding Grant's critique of the modern way of knowing will be broken up into 4 parts: the reversal of contemplation and action; 2, ignorance to its limits and the exclusion of knowledge; 3, knowing as willing and technological mastery; knowing as making. The reversal of contemplation and action places calculative will before deep thought and meditation on what is good. The language of the primacy of the will reigns true here, and it is not limited to the common man, but is also the dominant practice of the modern philosopher. The primacy of will, action over contemplation, which characterizes modern epistemology, inevitably leads us down the narrow path of philosophical pragmatism in pursuit of power and control. So that's a little general background on Grant. And I'm going to read from his work, Philosophy in the Mass Age, his chapter on natural law. And you can contrast with the world of the positivists, the power theories, modernism, and Wokism. Natural law. The theory of natural law is the assertion that there is an order in the universe, and that right action for us human beings consists in attuning ourselves to that order. It is the most influential theory of morality in the history of the human race. We meet it in some form wherever we go among the pre-scientific civilizations, in Greece, in Rome, in India, in China, and among the European peoples, up to the last 200 years. It is still the cornerstone of the ethical theory of the Roman Catholic Church. In the present desegregation issue in the United States, and keep in mind when this was written, 59. In the present desegregation issue in the United States, it is appealed to by constitutional lawyers in this instance, the suggestion being that men, by their very nature, have certain inalienable rights, irrespective of the color of their skin. Indeed, only in the last 200 years has it ceased to be the generally assumed theory from which moral judgment proceeds. It is popular to speak of a crisis in our standards and values. This sense of crisis arises above all from the fact that the doctrine of natural law no longer holds the minds of most modern men, and no alternative theory has its universal power. Not only are most people unaware of what natural law means, but when they learn of it, it seems somehow strange and alien to their modern perspective. As I explained in the last chapter, the doctrine of natural law rose among men in the ancient cultures as they passed beyond their mythic beginnings and began to think of the world as an ordered universe, which their minds could understand. They began to think about this order not only as it appeared in the planets, but also as it was exemplified in human action. In the Western world, which is our chief concern, it arose among the Greeks, who were the first to practice systematic science and philosophy. These studies presupposed that it was the nature of mind to seek that order which is manifest in the universe. The Greek formulation of natural law was taken over by the Romans as the theoretical basis of their great empire of law. The doctrine was later immensely illuminated by Christian revelation, as also, on the other hand, the Christian church was illuminated by it. It passed over into European civilization through the Christian church. The doctrine was the following: there is an order in the universe which human reason can discover, and according to which the human will human will must act so that it can attune itself to the universal harmony. Human beings, in choosing their purpose, must recognize that if these purposes are to be right, they must be those which are proper to the place mankind holds within the framework of universal law. We do not make this law, but are made to live within it. In this doctrine, certain assumptions are made. First, about the universe in general, and secondly, about human beings in particular. The assumption about the universe is that it is a cosmos and not a chaos. That is, it conforms to law, and to conform to law is to be held in being by reason. The great Roman lawyer Cicero puts this extremely well in his book De Legibus. In quotes, "What is more true," he writes, "than that no man should be so stupidly arrogant as to suppose that reason and mind are to be found in himself, and not to suppose that they are to be found in heaven and earth, or to suppose that those things which are scarcely to be comprehended by the highest reason are not themselves set in motion by reason. Since all things that have reason stand above those that are devoid of reason, and since it is blasphemy to say that anything stands above the universe as a whole, we must admit that reason is inherent in the universe." In Cicero's statement, the assumptions of natural law become clear. By law is meant not something simply human, which we make. It is that which at every point makes the universe what it is. It is that reason which is common to God and to men. The universe is a great system of beings, all moved by law and ultimately governed by the divine mind. It is a hierarchy in which all beings have their place, from the stones which obey the laws of the physical world, up to the plants and animals to man, and beyond man to the angels, and finally to God, who is reason itself. The noun nature and its adjective natural are other words for the order of the universe, and the nature of any particular thing is that which it is when it realizes its immanent meaning, that is, when it takes its proper place in the whole. To take an example popular in the ancient world, the laws of a beehive may be dictated by the instinct of the bees and the laws of a human state by legislation, but when the beehive or the state are what they ought to be, both types of law are an expression of reason and intelligence. They are reflections of that divine intelligence, which is the ultimate arbiter of all. So we may take it that the governments of most Western countries today are pretty far removed from this ideal. This view of the universe as a great chain of being bound together by mind must be understood if we are to see the moral principles of natural law which arise from it. Aristotle once said that the belief that there was a moral law depended ultimately on how we interpreted the movements of the stars. What he meant by this is that if we come to deny that the planets in their motion can be known as finally caused, we will eventually, if we are consistent, deny that there is any purpose or law governing human life. If we deny that, we are denying that there is such a thing as human morality. In other words, the doctrine of natural law depends unequivocally on the existence of metaphysical knowledge. Metaphysics is the study of reality as a whole. It asserts that we can make true judgments about reality. To speak of the nature of man, the order of the universe, final causality, or God, is to speak metaphysically. Obviously, when Aristotle asserts that there is a final cause of the motion of the planets, he's not giving a scientific explanation in the modern sense of the phrase. Yet only if we can affirm that there is metaphysical knowledge of this kind can we speak of natural law and deduce the principles of right action from that conception. In this sense, a natural law of morality stands or falls with metaphysical knowledge. The truth of this can be seen in history from the fact that the denial by modern philosophers that there is metaphysical knowledge has gone hand in hand with the criticism of the natural law account of morality. Secondly, this doctrine makes certain assumptions about human beings and the way they should live. It assumes that there is a human nature and that this nature is ultimately the same in all men. It does not depend on whether we are tall or short, black or white. This universal human nature is to be a rational creature. Our place in the hierarchy is to be distinguished from animals as being rational and from God as being creatures. With regard to human action, we have the power to determine for ourselves, through intelligence, the ends which are proper to us. This is not to deny that for the ancients, reason was immanent in a stone or in an animal, both of which were thought of as expressions of the law. Man, however, has a rational soul, as distinct from an animal soul. The ends which we pursue are not given us directly in the way they are given an animal through instinct. We must discover our proper ends through reflection. The believers in natural law saw clearly that our ability to reason about ends is not something given to us immediately. We are governed by laws which we only partly understand. Reason is at first only present in us potentially and not actually. It needs to be developed, and developed by education. Education is seen as the process by which a person comes to think clearly about the proper purposes of human life. How different this is from our modern technical education, which is simply concerned with teaching people how to get on, never with teaching them where they are getting on to. In the old theory of education, when a man began to see what was the ultimate purpose of human life, he was said to be wise, to have the virtue of wisdom. Wisdom was then the purpose of education. It was the condition which men reached through reason, as they came to know what were the purposes in human life truly worthy of a rational soul. To live according to nature was then the supreme good for a man, as it was for any being in the universe. But of course, our nature, being higher than that of an animal, depends of us a higher way, demands of us, a higher way of life than that which is good for an animal. The good life for man includes within it the perfection of his rational nature. Man is to be perfected and brought to his highest possibility through the union of his reason with the divine reason. Thus, the logical completion of natural law is to pass beyond a simply practical life to a life of mysticism. Practice passes into adoration. It is easy to see how this doctrine of natural law produced the fundamentals of our legal system. The law which is administered in the courts originates and derives its sanction from the eternal law of justice, which is at once the law of God and of nature. Worldly laws, the laws of the land, depend on that supreme law which preexists both written laws and the state itself. As late as 200 years ago, this was almost universally believed by practicing lawyers. The great English jurist Blackstone put it with clarity: this law of nature being co-evil with mankind and dictated by God himself is of course superior in obligation to any other. It is binding over the whole globe, in all countries, at all times. No human laws are of any validity if contrary to this, and such of them as are valid derive their force and all their authority mediately or immediately from this original. The distinction between natural and positive law was then clear. Positive laws are the laws which men enact, but they are only true laws insofar as they are in conformity with a law which is more than man-made. Cicero uses a very good simile to explain this. Suppose you go to a doctor and he, looking very wise, writes in his unintelligible jargon that you are to drink, and you take this paper to the drugstore, and the druggist makes up the prescription, and you drink it and find out it was poison. Was it a prescription that the doctor gave you? Yes, in a sense it was. A dose written down by a doctor to be made up by a druggist is a prescription. Yet the whole meaning and purpose of a prescription is that it should be for the advantage and healing of the patient. This is true of laws also. A law is only law when it is just law, mirroring the divine law of justice. Both conservatives and radicals have appealed to this doctrine. The radical has said that existing law was not in conformity with divine law and therefore should be changed. Conservatives have said that some proposed change was turning away from the divine law and therefore wrong. But in the past, both conservatives and radicals generally believed in this divine law from which they derived their judgments. Thus, for instance, the idea of a fair trial as necessary to a just system of law became part of the way we do things, because it was believed that all individuals have certain rights. Those rights belong to them by the very nature of things and cannot be taken away by the whim of others, by the officials of government, or by dictators, or for the convenience of democracies. Not only in the laws of the state, but also in the personal moral decisions of life was the doctrine of natural law operative. The right way to live could be deduced from the unchanging law, which is the reason and will of God. Moral conduct was therefore not considered a matter of convenience, but the attempt to actualize the eternal law in one's own life. The question of abortion will serve as an illustration. More and more modern states now allow abortion in certain circumstances. This is because abortion is believed to be something which you choose to do or not to do at your own convenience. This has not yet come officially into Canada. Well, this was obviously some time ago. It is very much here now, without any restrictions whatsoever. I digress. This has not yet come officially into Canada because the old tradition about this matter still lives on. But I think it is true that more and more people believe that abortion is a permissible act and practice it when the need arises. The traditional believer in natural law would say that abortion is a wrong act and that the wrongness of the act is not affected by whether it suits our convenience or not. It is a law of nature which we did not make and which we cannot alter. That we should not extinguish what is at least potentially human soul. This is why you come across in Greek plays or in Shakespeare the idea that being a dictator or committing incest is an unnatural act. These acts are looked upon with horror because they are contrary to what is demanded from us as human beings. The Germans have a word for this, which turns up in that matchless work of art, Mozart's Magic Flute. A dictator is called an Unmensch, or non-human. Dictatorship is not only wrong because it affects the convenience of other people, but also because it affects the dictator himself. To be a dictator is to fail in fulfilling one's manhood. And I should pass that note on to Mr. Trudeau. A dictator is to fail in fulfilling one's manhood. It does not belong to the order of being of man to rule other men at one's own whim. It is plain what is clear and powerful. It is plain what a clear and powerful doctrine of morality natural law was. It gave to those who held it a sure and certain sense of direction. First and foremost, the doctrine was clear that moral standards are not relative but absolute. Right action was not considered a matter of our convenience. The objective moral law does not depend on what we think. As sophisticated a practicing lawyer as Cicero said, and I quote, "Only a madman could maintain that the distinction between honorable and dishonorable, between virtue and vice, is only a matter of opinion." Such a quotation illustrates how far many people in the modern world have departed from the doctrine of natural law. So often one hears modern people who have some education say that right and wrong are just matters of convenience or of opinion, and that therefore there are no absolute moral standards. How influential this is in our society can be seen from the fact that the late Chief Justice Vinson of the United States Supreme Court could state this in a legal judgment as if it were so obvious that it did not need arguing. And those who take this view often think they have proven it when they point to the fact that people have believed different actions to be right at different times and places. Indeed, the belief that there are absolute standards of conduct is often supposed to be a very unsophisticated belief, held only by simple people who do not know what the score is. After one has attended university or the cocktail parties of the prosperous, one will give it up. In Canadian history, how many people have come to university from well-defined moral backgrounds and been taught that a man wise in natural or social science is educated when he is a skeptic about moral questions? This used to happen more often than it does now because most people are now brought up in a world where this moral relativity has become the tradition. Imagine, this is 1959. Indeed, we are told from our earliest youth by the psychiatrists and their publicists that belief in absolute standards is positively unhealthy and will at least lead us to difficulty in adjusting ourselves to society, and at the worst will lead us to the mental hospital. The second implication of the doctrine of natural law is that reason leads us to know what is right. The good man is the reasonable man. The believer in natural law took for granted that reason could be practical. The vast range of particular desires did not appear to him simply as a chaos, because reason could present to him that idea of a highest rational good in terms of which all his desires could be brought into an intelligible and ordered system of life. The idea of the highest good was that in which not only particular desires would be satisfied, but that in which the total self would find its completion in happiness. The doctrine distinguished between happiness and pleasure. This highest good was the purpose for which life was lived, and all our particular purposes should be subordinated to it. But this highest good could only be known through reflection. Therefore, the life of reason was the most important thing for the individual and for society. It was this, indeed, which led people to take the life of philosophy so seriously in the ancient world. If reason could be the ultimate governor of life, if the good life was a rational life, then philosophy became very important. To repeat, it was believed that a man's reason is at first only potential and needs to be developed. The very word philosophy meant that. It was a combination of the Greek word philo, meaning love, and the word sophia, meaning wisdom. Philosophia, the love of wisdom. Philosophy was the attempt to incarnate wisdom in our very lives. This is what Plato is saying in his Republic, and what Aristotle is saying in his Ethics. How different is the importance granted to the life of reason in our Canadian institutions? Reason is generally thought of as an instrument. Practical reason is a means which can help us to achieve what our passions lead us to desire. But it is these desires and not reason which are considered as ultimately determinative of action. This is why reason to a North American is generally thought of as scientific reason. For scientific reason is concerned with the external and its control for human purposes. It is not concerned with what human purposes are good. This again can be so clearly seen in our educational system. Education is concerned with teaching young people techniques by which they can do things in the world. There is almost no concern in our educational system with seeing that our young people think deeply about the purposes for which these techniques should be used. Just look at the training of our engineers and scientists. Although we call the Russians materialists, we must remember that they give their young people more time in their curriculum to look at such questions than we permit our students. The question, for what purpose, we leave to the ministers and even more the psychiatrists, the new ministry. We believe that such questions are fundamentally answered if we cultivate in young people certain emotional attitudes. Reasonable discussion of moral purposes has therefore almost entirely disappeared from our schools and universities. It must be emphasized that the doctrine of reason as a subjective tool of our convenience is held not only by the mass of people, but by the most influential philosophers of our day. As famous a philosopher as Bertrand Russell repeats over and over again, that thought is not the arbiter of human action, that it has no ultimate voice in telling us what is worth doing. And of course, no philosopher has such influence over the semi-educated of the English-speaking world in the last generation. When the doctrine of natural law is compared with modern theories about morality, one issue stands out as a central point of divergence. It is this point of divergence which I want to emphasize more than anything else in these essays. To put this issue simply, are we truly and finally responsible for shaping what happens in the world? Or do we live in an order for which we are not ultimately responsible, so that the purpose of our lives is to discover and serve that order? There are philosophers, Hegel for instance, who have claimed to include the truth of both these sides in their philosophies, and thus to have reconciled this divergence. Whether or not they have succeeded is not our concern here. What matters first is to see how divergent are these ways of looking at the world and what different moralities they must lead to. In natural law theory, it is clear that man is not finally responsible for what happens in the world. He chooses to conform or not to conform to an order which he himself does not make. But as the individual only has reality within the system, if he chooses not to conform, then the order simply breaks him and brings his efforts to naught. And woke should learn something from that. To go against the natural law is both for society and the individual to descend into chaos and nothingness. This means that finally, the individual has no choice but to accept the God-given order. The theorists of natural law use the words choice and freedom in a much more limited sense than that of the popular usage in the liberal West. Freedom does not mean the ability to make an unambiguous choice between open possibilities. We become free only insofar as we base our relevant actions on the law. We lose our freedom as we disregard that law. Thus, in traditional Christian theory, the highest stage of the good life is to be beyond choice. To be free is to be a slave. As St. Augustine puts it, to be able not to sin is a great liberty. Not to be able to sin is the greatest. What is ultimately important to a man, then, is to know that he is not his own, that he is a creature who did not make himself. A modern exponent of natural law, George MacDonald, put the doctrine very clearly when he wrote, in quotes, "The first principle of hell is I am my own." How different is the humanist view of life? Man makes the world, and there is no overall system which determines what he makes. To act is to choose what kind of a world we want to make. In our acts, we show what things we regard as valuable. We create value. We do not participate in a value already given. We make what order there is. We are not made by it. In this sense, we are our own. We are independent. We are not bound by any dependence on anything more powerful than ourselves. We are authentically free because what happens in the world depends on us, not on some providence beyond our control. The fate of man is in his own hands. We, and not God, are the creators of history. You can see the hysteria related to climate change or the global reset and all that stuff. It's rooted in this belief that everything depends on them, that they have total control. And of course they don't. To put the issue in this simple way, are we our own? Are we our own, or are we not our own? Is not to imply that any kind of intelligible answer can be discovered simply or quickly. To begin to answer such a question would first require careful analysis of such words as freedom, law, adoration, the making of history, and many others. This issue takes us to the heart of the relations between metaphysics and ethics, and between religion and morality. It is with such systematic analysis and synthesis that moral philosophy is concerned. What is first necessary is to say something historical about why modern Europeans came to criticize and to reject the doctrine of natural law. Even a preliminary account of such criticism goes to the roots of the history of the Western world in the last centuries.